So you've just become executor of somebody's estate. Now what? Hi, Nancy Beauvair here with a Gappy and Next Steps. What happens when you become executor of somebody's estate? In most cases, when somebody is named to be the executor on somebody's estate in their will, they've been notified of it, so they have advance notice. Sometimes they don't. But typically, people agree to become the executor when somebody passes away because they love the person. They feel a sense of obligation or duty, but they don't know what it entails. They don't know that there's going to be complications because they're dealing with grief. Well, that's what this video and this week's article is all about. I put together a bit of a brief survival guide, if you will, for executors, so that you have a bit of advance notice to know what is coming, what you can expect, and be a little bit more prepared. Becoming an executor is something that most people only encounter once. I spoke to a woman this morning, and in the last year, she has been executor on 3 different loved ones' estates. That's, to me, just like overwhelming. There is so much to do. People just don't understand when they agree to take on this role just what is involved. You think that it's a matter of filing some paperwork, distributing some property, maybe splitting up some heirlooms among the family. But the reality is that this does come with a fiduciary and therefore a legal obligation. Most people don't understand that when they take on that role, there is a potential liability. Any of the other beneficiaries can at any time make a claim that you acted inappropriately with the estate when you were handling the estate. That doesn't mean that those allegations are true, but if there is a perceived issue, those people can file a court challenge, and it would be up to you to have to defend yourself in court, and that comes at a cost. It takes time, it takes an emotional toll, so you have to think very carefully about that part of this role as well. Don't just think about the love and the care and the obligation that you feel to the person, which is great, but make sure that you're weighing it and make sure that you're prepared for what comes with it. Now, the other thing is that estates do not close quickly unless they're extremely simple estates that do not require probate, that it's very limited in assets, very limited in financial resources. It typically is going to take a minimum these days of 18 months before it gets settled. There's a lot of things that are involved. There's planning the funeral, there's gathering and protecting the assets of the deceased person. There is, if there's real property, there is the maintenance and the required sale potentially of any real property that can't take place until probate has happened. And probate, depending on where you live, depending on how busy the courts are, obtaining the grant of probate can take anywhere from 4 months to 8 months, or in some cases, even longer. So that property will have to be maintained until that grant of probate is given, which gives the executor the authority to access funds to maintain the property, to be able to have their name on the title with the legal right now to dispose of that property. All of this takes time, it takes effort, it takes money, it takes patience, and all of this is wrapped up with your own emotions. Most people will name a family member as their executor. It's the people who know them the best, so why wouldn't you have somebody who knows you be your executor? But those people are also trying to navigate their own grief at the same time that they're trying to take care of all the administration, all the legal obligations, all the tax and accounting issues. All of those things take their toll. And don't forget, too, that often there are beneficiaries. Again, nobody really understands the process until you've gone through it. So a lot of times beneficiaries will come knocking on the executor's door and they want distribution of what's their share of the assets or what was granted to them in the will without understanding that that can't be done until all of these steps happen. So it can create rifts in family members because they just don't understand the process. It's not an easy thing, and it's not something to be taken lightly. But that doesn't mean that you shouldn't do it. It should be something that if you feel good about doing it, then by all means, I think that that is a wonderful thing. But remember, you don't have to do it alone. I'm a certified executor advisor. I have a couple of packages that are available. One helps with the early preliminary stages, what you need to do to get through before the process closes. The other program will take you all the way from the beginning, all the way to the closing of the estate, which could take, as I say, 18 months, 2 years, or longer. So you don't have to do it alone. If you have questions, if you have the need to have any kind of assistance, somebody who has been there, who has walked through this a number of times and knows how to cut through some of this red tape. You can reach out to me in a couple of ways. You can either, if you think that you're ready to purchase already a package that is going to help you, you can do that. Or why not just get a complimentary 20-minute conversation? We can see where you are, and then I can help walk through what is the best option for you. You don't have to hire me. There are other certified executor advisors. There's other people who are more than qualified to help. But if you do find yourself in a position where you need some advice, need some support, reach out and I will see how I can best assist you go through this process. I just want to remind you as well in closing here that there is a process that has to go through. Don't feel backed into a corner with any expectations of any of the beneficiaries. You do have a legal obligation, and point that out to them that you cannot do anything until certain milestones have been achieved in the whole process. You know, in one case that I know of, the executor went into the home, changed the locks, locked other members out, distributed the assets within the house before even receiving the grant of probate. Now, in this case, he was very fortunate because there was nobody that filed a claim against him. But he had absolutely no right to distribute any of those assets until the court had provided him the grant of probate. And then at that point, there's a process to go through before you distribute those assets. So what you don't know sometimes can hurt you. I'll leave that with you. If you go over to the website, I've got, as always, more fleshed out article about this. So check it out. I'm sure that you'll find a lot of the information there useful. And again, anytime you have any questions, just please reach out. Thanks very much for joining me again this week, and I look forward to sharing more with you again next time. Bye for now.